I want to say thank you all for coming, and I mean it, but I mean it kind of in the sense of having been at the 1996 convention in San Diego. The president, or it was candidate Dole, looked out to everybody and waved, and he was looking at a wall. It was all for the cameras. He was pretending that there were people in front of him because he was in a kind of a narrow space and people were on the sides. But anyway, for those of you who came, thank you very much for coming. Today is Hofstra University's Civil Rights Day. Civil Rights Day is normally recognized in January, but because we aren't together on campus in January, we moved it to February during Black History Month. I was told today that this event was created by the Center for Civic Engagement some 15 years ago, and if I'm wrong about that, I hope to be corrected. I wasn't then, but I am now the director of the Center for Civic Engagement. My name is Phil Dalton, and I am also a professor of rhetoric and public advocacy. Black History Month gives us in the United States plenty to think about. And while much is positive, there remains a great deal that we need to hold up to scrutiny. I firmly believe we should not be shielded from the discomfort our history or our present generates. Tonight's topic emerges from countless events involving citizens creating their own justice. Ursula Ori, in her book, Lynching, Violence, Rhetoric, and American Identity, points out that lynchings are not only the images of strange fruit murders, the images of which remind us of America's dark, distant past. Lynching is extrajudicial killing, extrajudicial justice, and they still happen today. The killing of Trayvon Martin, she argues, constituted a modern-day lynching because it was legal and because it met a second requirement of such acts. His killing, she argues, was intended to send a public educative message. In that sense, Trayvon Martin's killing belongs in a group of extrajudicial, quote-unquote, justice events in recent years or in recent months, including the killing of Ahmaud Arbery and the Kyle Rittenhouse killings of two white men at a racial justice protest in Kenosha, Wisconsin. I bring these events to mind tonight to lay the groundwork for the content of tonight's discussion titled Vigilantism in the United States, a Start with No Finish. The latter two events that I mentioned, in fact, led the discussion the day this program was conceived. It gives me great honor to introduce tonight's speakers. Our first speaker is Professor of Law at Hofstra's Maurice Deane School of Law, Professor Mark Niles. Professor Niles specializes in civil procedure, constitutional law, administrative law, and government liability. Among numerous achievements, Professor Niles is a Stanford Law graduate, former professor and associate dean of student affairs at American University, Washington, and dean and professor of law at Seattle University School of Law. Our second speaker is Long Island civil rights attorney, Fred Brewington. Raised on Long Island, Mr. Brewington has become a respected lawyer and community advocate. With his expertise in civil rights litigation, he has fought for voting rights, opposed discriminatory housing practices, championed community revitalization, employment rights, civil rights, environmental justice, and fair representation in government. So thank you both for being with us this evening. And before we begin tonight's event, it's necessary to recognize those who helped make the event possible. I extend many thanks to the Center for Civic Engagement, my center, and the people involved in it, the Center for Race, Culture, and Social Justice, and the Hofstra Cultural Center. These events continue to come off successfully because of the care and attention to detail of Athleen Collins, Carol Mallison, Janine Rinaldi, and their colleagues. Thank you very much. Tonight, both of our guests will speak, I said roughly 20 minutes, but we'll see how it goes. I saw the number of slides you have. At around the 20-minute mark, however, I'll give you a nod, and I'll motion for you to be aware of time. When our speakers are both done, I hope to have a lively discussion. You're all invited to approach the mic and speak when that time of the evening arrives. But now it gives me great pleasure to invite Professor Niles to come speak to you all.
So I can unmask? Yes. Awesome. Wow, it's the first time doing that in a long time.
I've been teaching in person for 2 years, and so it's very nice to speak without this thing in front of my face. So thank you, Phil. That was actually a wonderful introduction. Thank you very much, and I appreciate very much what you said. So I kind of feel like I'm the opening act here, and with most opening acts, I think the follow-up is going to be much more interesting than me. But what I want to do in a very sort of professorial way is really to lay the groundwork for a lot of what Fred is going to be talking about in terms of the actual work that he does day to day as a civil rights lawyer in this area. So I want to talk a little bit about the history of race-based and other sort of issues of subordination and violence that has occurred in the United States based on our history. And I think as a professor who teaches, among other things, civil rights law, to talk a little bit about what the legal remedies are to address these sort of issues. And I think that leads very well into what Fred's going to talk about, because he's someone who works with these mechanisms and with these devices really every day in the work that he does to promote justice in this area in the country. So just to start, just a little bit of a outline. Again, I'm a professor, so what do I do? I'm going to talk about these topics a little bit and try to do it quickly so give everybody more time. There's one additional thing that I'm going to add here is talk a little bit about hate crime laws. I don't really teach about hate crime laws because that's more of a criminal law issue than a civil rights issue technically. But there's so much going on right now, and obviously with the hate crimes trial right now of the people who killed Ahmaud Arbery, I thought I would mention that a little bit because I think it might be interesting to folks. And also talk about the New York hate crime statutes, because there's such an issue, certainly in Manhattan, and I'm sure in the rest of the state, about issues around hate crime involving particularly Asian Americans and Jewish Americans and other folks. So it seems like an important topic for right now. So talk about a little bit about the civil rights history pre-Civil War, Civil War, and the follow-up from that. The role of the federal government versus the state governments in terms of addressing these issues. The Civil War amendments flows from that. Reconstruction, post-Reconstruction, and then the new civil rights movement, sort of the mid and later parts of the 20th century, the impact that had. That's where I think I'm going to fit in my little talk about the hate crime laws. And then I want to talk a little bit about civil rights beyond sort of the black and white and racial issues, and ways in which civil rights issues have addressed things like sexual orientation and disability and other things, just really quickly to give folks a sense that when we talk about civil rights, we're not just talking about race, even though that was maybe the foundation for it. And then finally, a little bit about New York State's civil rights laws and the things that that addresses. Okay, so I want to talk a little bit about pre-Civil War. Civil War is often a place where people focus in terms of talking about these things, but there are all kinds of issues about racial discrimination and racial violence long before we got to the Civil War. Perhaps most obviously with Native Americans or First Nations people, and all the ways in which our society engaged in violence, vigilante violence and otherwise against them. There was a famous case, Cherokee Nation versus Georgia, pre-Civil War, where the Cherokee Nation sought a federal injunction against laws passed by Georgia depriving them of rights within their boundaries. And the Supreme Court didn't hear the case on its merits. It ruled that there was no original jurisdiction in the matter, as the Cherokees were a dependent nation with a relationship to the United States that was a ward or its guardian. One of the things that evolved over time was the ongoing treatment of the First Nations as separate countries, and that's led to reservations and other sort of things that we see developing. That's obviously a very big thing in this state. There's a very significant presence of tribes and bands that have a lot of impact on what's happening in society. Gender discrimination, obviously, in the period, you didn't have voting rights for women until 1920, several decades after you had voting rights for black men. So acknowledging again that civil rights isn't just about racial issues. Fugitive slave laws, I keep putting 19s in here. I meant 18s. I need to check that. So 1850, U.S. Congress agreed to a compromise. So there was a lot of concern. So with the Underground Railroad, which is another thing that has been very prominently talked about, there was a recent television series that addressed that, and a very famous book recently that received, I think, the Pulitzer Prize about the Underground Railroad. The success of the Underground Railroad led to various things, including Congress creating a fugitive slave law, which required communities to identify, find, and return escaped slaves to their original masters, and under sort of federal law and structure. And that was one of the major precursors to the Civil War, because of the ongoing belief that people in the North couldn't escape the consequences of slavery if they were going to be complicit in the aspects of slavery by having to return people under those circumstances. Dred Scott versus Sanford sort of arises from that. Dred Scott was a person who had escaped slavery and brought a lawsuit, and it's complicated procedurally, but essentially what the court concluded was he was not a citizen of the United States, because as a former slave, as a black person, he couldn't be a citizen because the original intent of the framers of the Constitution wasn't to allow folks of that racial background to have citizenship rights. It's a very important moment in understanding the nature of racial segregation and racial oppression within the country. Dred Scott is an example of that. Again, all that is pre-Civil War. So then we get the Civil War, obviously a war that was fought centrally about the institution of slavery and whether it would persist in the country. And during the Civil War, as an executive order, not something that was passed by Congress and not something that applied everywhere in the country, President Lincoln issued the Emancipation Proclamation in 1863. I think I have the date right there, yeah. Which essentially, and I think most people know this, but not everybody does, it didn't free all the slaves in the country. It only freed those slaves in states that were currently under fighting in the war against the United States, who were under rebellion. It was very much a war measure, and Lincoln was very concerned about whether he had the legal authority to engage in that action. But obviously, it was still an incredibly important historical moment. It was the first time that there was any sort of legal acknowledgement of the freedom from slavery, the people who were otherwise in bondage. And you can see the language there in terms of the specifics of what was talked about there and the limitations as to who was freed under the circumstances. So perhaps most importantly in terms of the history of the country is what happened after the Civil War. So various things important in terms of what we're talking about. And again, what I want to talk about a little bit is the legal responses to vigilantism, the legal responses to violence based on race and other repressive motivations. And we see the beginnings of those responses in the post-Civil War era. Because what we see primarily is a new way of thinking about the country and the role that the federal government played in the country. The Ken Burns' Civil War documentary, which is probably about 30 years old now, there's a talking head in that who says that one of the differences between the way the country was before the Civil War and after is that people before the war said the United States are, and after the wars they would say the United States is. The notion that it was one unified entity was something that culturally made sense to people. And the federal government responded to that notion by really asserting itself, particularly in the area right after the Civil War regarding violence based on race, as a true national government that would impose restrictions and rules that would apply in all the states and not just rely on the states to, among other things, protect citizens of different races who were subject to the violence that they were experiencing. So the federal government played a new role. There's a new approach in terms of thinking about how these things worked. And it also involved, again, post-Civil War, a particular focus on the treatment of the millions of people who had been in bondage and now were immediately free after the Civil War was over. And you can imagine how complicated and how sort of demanding a burden that seemed. How exactly do we address this immediacy of these new citizens who were part of the country? And that was a huge part of what the federal government had to deal with for really decades after the Civil War was over. So one of the things we get after the Civil War is what we call the Civil War Amendments, the 13th Amendment, 14th Amendment, and 15th Amendment. 13th Amendment made slavery illegal, but as Fred and I were talking about a couple days ago, it's a lot more complicated. You look at the actual language and you see that slavery was made illegal except for, and this is the exception, except for punishment for a crime whereof the party shall be duly convicted. And not only does that create the potential for ongoing sort of slavery type limitations, but it was utilized by many people in the former Confederate states to create sort of an ongoing pseudo system of slavery by having laws and regulations, including things like vagrancy and other things that someone could be arrested for, then convicted, and then essentially sold to some sort of private party to work in a chain gang for an extended period of time. So one of the things that 13th Amendment did that is quite ironic in a sense is at the same time that it freed millions of people, it also created the possibility for ongoing subjugation of those same people. 14th Amendment, maybe the centerpiece of our federal government going forward after the Civil War as it relates to race and lots of other things too. 14th Amendment essentially says this: states have to treat everybody the same, regardless of their race. States also must protect those rights that the Constitution enforces as it relates to the federal government. So again, as a lot of people know, but a lot of people don't, we have the Bill of Rights before the Civil War, protecting things like your right to free speech under the First Amendment, your right to bear arms under the Second Amendment. Those rights did not apply to state governments until the 14th Amendment was passed. So you didn't have a right to free speech in the state of Georgia if it was the state of Georgia that was restricting your rights. That was a right you had that prevented the federal government from restricting your rights. But the 14th Amendment changed that. It took those things that made you a national citizen, and it protected those same things and those same rights as they applied in state governments. And that was a dramatic, really revolutionary change in the way the country worked. And the 15th Amendment allowed for the rights of citizens to vote against citizens, men, not women. It took many more decades to get to that point. But it precluded restriction on voting based on race in the entire country. And again, much like the 13th Amendment, that was a somewhat Pyrrhic victory, because much of what happened for decades after the passage of the 15th Amendment was ongoing systematic actions both by the official government entities and also unofficial entities to work as hard as they could to make sure that as few black people voted in elections as possible. The early part of the post-Civil War era, which is often called the Radical Reconstruction, involved the occupation of the South by significant forces of the federal government, the federal soldiers, who enforced the requirements of things like the 15th Amendment to allow for voting across racial lines. And that resulted in many things, including the election of several statewide officials who were black, so senators from southern states, Mississippi and Georgia, other sort of elections, a significant increase in that political representation. But, and it's too long for us to talk about today, as a consequence of various political things that were happening, including a very close election where there was a agreement made between the Republican and the Democratic Party, the Radical Reconstruction ended in 1877. And essentially the federal troops were removed, and the circumstances in the South were left to the devices of those local and state leaders. During this period, though, during the Radical Reconstruction period, right after the Civil War, two very important statutes were passed pursuant to this new way of thinking about the federal government's role in this. Civil Rights Act of 1866 and the Civil Rights Act of 1871, also known as the Ku Klux Klan Act, because the main focus of the Civil Rights Act of 1871 was to deal with exactly what we're talking about today, which is vigilantism based on sort of racial oppression. And I just wanted to mention, and these are things I teach in my civil rights class, but 4 of the statutes that are currently on the books that come directly from these laws still exist and are still applied, and I'm sure Fred still works with these statutes every day. So 42 U.S.C. 1981 provides that persons shall have the right to enforce contracts regardless of race, and this is very important when you think about the fact that employment contracts for the sale of your house, buy of your house, contracts are centrally important. Even if you didn't go to law school, you know contracts are essentially important to the way people interact in life. 42 U.S.C. 1982, all citizens shall have the same right in every state territory to inherit, purchase, leases, also very important. The big one, though, 42 U.S.C. 1983, my civil rights class is essentially a class totally about litigation arising from this. It's basically what we call a private right of action to seek a claim alleging a constitutional violation. So if someone violates your constitutional rights as part of their official duty, a police officer who engages in activity that is inappropriate, a prosecutor who withholds evidence, any range of people, the principal of a school who suspends your kid because your kid came to class with a peace sign, whatever it might be, whatever range of things. That's what Section 1983 allows for those claims to be brought in federal court. And finally, and this was something that was somewhat obscure until very recently, 42 U.S.C. Section 1985, which provides a civil remedy in cases involving conspiracies to interfere with civil rights. And the reason why this became a more prominently focused on part of the civil rights laws was that the Charlottesville case involving the death of the protester who was killed by a white supremacist, the civil action that was brought successfully, well, actually, the civil action that was brought successfully included a claim pursuant to this statute, but actually this claim, there was a hung jury. The jury didn't reach a verdict on it, but there were a couple state law claims for which they did. So this really brought it back into prominence, and I think you're going to see more litigation using this provision in the future. Okay, so after Radical Reconstruction, there was the Jim Crow era where, as I said, the federal government got out of the way and you had really decades and decades of the reinstitution of very restrictive and really very violent rules and structures in states. So it wasn't just that people were being restricted from access to civil rights, but there was ongoing vigilantism, ongoing examples of violence being perpetrated that was essentially if not done by sort of the official, those in official positions, at least countenanced by and sort of participated in those activities. And that was a significant part of the experience of the folks who lived during those decades. Plessy versus Ferguson was decided at that time, and very important case in terms of the nature of the dynamics of race in the United States, because what the court held in that case was that the Equal Protection Clause, which was part of the 14th Amendment, which I mentioned before, which said that everybody had to be treated equally, the court held that it's okay to treat people equally but separately, that separate railroad cars or separate schools based on race do not violate the Equal Protection Clause as long as they're sort of equal in terms of the provisions they apply. So separate but equal is the phrase that the court uses there in terms of the Equal Protection Clause, and that was something that existed in the United States until 1954 with the Brown decision, which finally changed that. So Brown in 1954, the NAACP Legal Defense Fund, at the sort of the leadings of a couple very prominent lawyers, Charles Hamilton Houston and Thurgood Marshall, had a long time process to do the sort of thing again that Fred does as a career, which is to bring civil rights claims on behalf of people whose rights are being limited or violated. And they started with lawsuits against law schools. They started with law schools against medical schools. And they were essentially challenging this notion of separate but equal. And one of the central arguments that Thurgood Marshall was making again and again is that these systems aren't really equal. If you have a law school in a state, and then you have a law school for the black students, and there are 3 students in it, and they don't have no alumni, they have no professors, they have no building, that can't be considered an equal situation. But the argument evolved to a broader point, and this is essentially what the Brown case is decided on. Even if you did have technically or physically equal facilities, it's never going to be equal in a society that has this history of racial discrimination to have this separation, because the separation communicates, and this is what the court says in Brown, it communicates a sort of society-wide oppression of one race as opposed to the other. What the court had said in Plessy versus Ferguson was, if you separate blacks and whites, if the blacks want to feel like that is some sort of a negative connotation on them, that's on them. If that's the way they feel about it, then they can reach that conclusion. But the court said in Brown, obviously that's ridiculous, because in the history of this country, that separation is always going to be a communication that one race is superior to the other, and that's the nature of it. And that was the heart, that was really the heart and the center of Brown versus Board of Education, that any kind of separation based on race in this country, given its history, is going to communicate a subordination that violates the Equal Protection Clause. So that's really the key to that opinion. So 10 years later, we have civil rights movement rising from various things, starting in the 50s and 60s, again, beyond the time that we have here to talk about. But in terms of the legal stuff and the stuff that I really want to give you guys a background in, we have some significant gains in terms of laws that were passed in this period, primarily in the Johnson administration, initiated in the John F. Kennedy administration, but ultimately signed under President Johnson. The Civil Rights Act of 1964, which included Title II, which I just taught about in my constitutional law class, which made discrimination in public accommodations illegal, so hotels, restaurants, things like that. The case that affirmed the constitutionality of Title II was decided in 1964, which resonates very much personally with me, because in 1963, my parents got married. My dad drove down from Washington, D.C. to Greenville, Mississippi to marry my mom, which is good for me, because otherwise there'd be someone else here. And he went down with his best friend, who was from Cleveland, and they drove the whole way through because there was no place they knew that they could stop. There wasn't a place they knew they could get some food, where they could be able to stay. They got down there, and my dad tells the story with a bit of a wry smile, but his future father-in-law was the one who found him a place to stay. So the first time he met his father-in-law was when his father-in-law said, okay, you're going to stay over here on the couch of these people who are nice enough to let you stay, because before the passage of the Civil Rights Act, there wasn't really many other options for folks under those circumstances, particularly in the South, but other places too. So that one sort of hits home with me as much as anything. Voting Rights Act 1965 addressed the ongoing, both official and unofficial repression of voting rights and voter suppression, created structures that attempted to address that. And this has also been in the news recently because several recent Supreme Court opinions have undermined the power of the of the federal government under the Voting Rights Act. My daughter wrote her thesis in college on one of these cases, the Shelby County case, which limited the effectiveness of of the Civil Rights Act, and this is, the Voting Rights Act. Again, something very much in the news right now. So Fair Housing Act also addressed housing rights in sort of different other ways. And you see oftentimes the equal housing, and you see these different things. That was another thing that came from the federal government's increased presence and activity, not in the states, not relying on the state governments to do these things, but having the federal government play a significant role. Okay, I want to make sure I'm not going to go over my time. Okay, so hate crimes laws. So I looked into this the last couple days, and I'm not a big expert on this, but really I've heard about it so much in the news, I thought it would be good to give you guys a basic background on it. The first hate crimes law was passed in 1968, again, in the Johnson administration. And it was 18 U.S.C. 245. Violent interference with federal protected rights was what it was sort of titled or focused on. And Congress made it a federal crime to use or threaten to use force to willfully interfere with any person because of race, color, religion, or national origin, or because the person was participated in a federally protected activity such as public education, other things you can see there. And so when we talk about federal hate crimes, generally they're founded on this statute. And what you basically have in a hate crime situation is a crime that occurred, so there's already something, it's already an underlying crime. But what you have to prove and what these federal prosecutors are going to have to prove, and this is the statute that the federal prosecutors are right now charging in a trial that's happening now in Georgia about the Ahmaud Arbery killing. You have to prove, in addition to the fact that these people intentionally killed someone, that their motivation was based on racial animus. So I read a story just today in terms of the testimony in the trial. An FBI agent testified about a long string of racist emails and other notes that the assailants had passed along to different people as basis for the evidence to show that their animus towards people of color was a basis for the decision that they made to kill this person. And so it's understandable it would be under this law. More recent laws have expanded what we see as a hate crime beyond just racial issues, or at least beyond just white versus black racial issues. So 1996, Church Arson Prevention Act. And then 2009, another big moment in terms of the development of federal law was the Matthew Shepard and James Byrd Hate Crimes Prevention Act. I'm old enough to remember the killings of both Matthew Shepard and James Byrd around the same time. One person killed pretty obviously because of his sexual orientation, another person killed because of his race. And combining those two victims, this law makes it a federal crime to willfully cause bodily injury or attempt to do so using dangerous weapons because of the victim's actual or perceived race, color, religion, national origin, gender, sexual orientation, gender identity, or disability. And I wanted to mention that along with a couple more things I'm going to do before I close to, again, remind us that when we talk about civil rights, it's a broad focus, it's a broad concern that doesn't just address people of color, but addresses people who are subject to sort of oppressive treatment and oppressive thoughts based on all kinds of factors, their religion, their sexual orientation, their gender identity. And it's very important to remember as we talk about civil rights how far and how importantly it is that we apply these analyses that far. Okay, so New York State Penal Code has its own hate crimes law, 48.051. Person commits a hate crime when he or she commits a specified offense and either intentionally selects the person or commits the act against whom the offense is committed or intended to be committed in whole or in substantial part because of belief or the perception regarding the race, color, national origin. So very similar to that original 1968 federal law. And again, a different sort of thing to prove, and many people argue very hard to prove. Very hard to prove beyond a reasonable doubt, which is what you need to prove in a criminal case, that the person committed this crime, not just because they were going to commit a crime to anyone, but they committed the crime specifically because of some identifiable feature about the person that was the victim. So again, in terms of the news, and very tragically, a recent stabbing of a woman, an Asian American woman in Chinatown, to the extent that there is an attempt to make hate crimes charges in this, how easy will it be for the prosecutors to argue that this wasn't just any other kind of robbery and killing, but that it was motivated by these sort of interests? I do think it's important to have laws that address these issues, so I do think it's a different kind of crime, a different kind of harm. But I think criminal attorneys, prosecutors, and defense attorneys will tell you it's a very hard thing and a very complicated thing to do. But I wanted to mention those because there's so much in the news right now. So civil rights beyond race, other things that we have that are within the civil rights realm around the same period and more recently, Equal Pay Act of 1963 addresses specifics of gender discrimination as it relates to how much people are paid in the workplace. Age Discrimination and Employment Act addresses discrimination against people based on their age, makes it a federal crime to make employment decisions based solely on the age of someone who's working there, which was not a crime until 1967. Title IX of the Education Amendments in 1972 has a huge effect on everything that goes on in this place, because Title IX requires any educational entity that receives federal funding, which is pretty much every educational entity in the country, to have equal treatment of students and faculty based on their gender, which has had a huge impact the last 50 or 60 years on the nature of coeducation in the United States. Americans with Disability Act of 1990 deals with people with physical and other sorts of impairments, and it's like everything else. It's a complicated history, but I think most people, advocates in this area, will tell you it has been a hugely positive impact, even though there's a lot of work that needs to be done to make sure it's as positive as it should be. And all kinds of things, obviously, the carts, the ramps that you see, and all the kind of other things that you see in your life are all responding directly to this federal law. Violence Against Women Act of 1994 also addresses a specific problem, which is violence against women based on gender motivation. So another vigilantism concept. We're talking here really about violence and all the ways in which legal tools are supposed to address or try to limit or prevent or provide remedies for that violence. And the Violence Against Women Act is another example of expanding out that concept beyond just the concept of race. And then finally, just quickly, just a little bit of a note of, again, state civil rights laws. These are the issues that the New York state civil rights laws address. There's a Bill of Rights that provides rights to everybody, equal rights to public aided housing, privilege from arrest, equal rights to places of public accommodation, rights of persons with a disability, and rights of privacy. New York has pretty expansive civil rights laws. Maybe that's not a surprise. I think it's a good thing about living in this state. They have protections that apply. There is a right to housing, a right to shelter, which is not a federal right, which is true in the state and very few others, and other things that New York does that are different and more expansive than you see. And one of the things that you see in the generation that we're currently in is sometimes, whereas 50 years ago, the federal government was usually in the lead in terms of expanding the concept of what rights citizens have. Now we see it the other way around often, that it's the state governments that are ahead of the federal government in terms of expanding what we see as civil rights protections, and are often maybe the place to go to try to address these concerns as opposed to the federal government. That's been a big change that for someone my age is kind of hard to grapple with, but certainly something that I think we'll see more and more over the next couple decades, either fortunately or not. So that's background I wanted to give, just a basic sense of the way that the law provides remedies and addresses these sort of concerns broadly around racial discrimination, but also around vigilantism, one of its most stark and obviously violent manifestations. And I thought that'd be a good lead in to Fred, who's going to talk to you a little bit more specifically about the work that he does day to day and the impact that he has in representing people who are suffering from these issues. So thanks very much. That's the least I can do.
Let me just First of all, hello everybody. My name is Fred Brewington, and it's good to see folks. I see some familiar faces. Well, I see some familiar outlines of faces behind masks in the room. Let me just start by saying that what we just saw was remarkable. Oh, yeah, I'll get it.
Get it for you, so
Oh,
it's showing
to start it? Oh,
Okay.
yeah, I'll say that. I'll talk. Oh, how about this?
So if we go on there, it'll show the whole thing.
I was gonna set it up. There we go. Okay. Look at that, huh? What we just saw, aside from the help that I just got, was remarkable. Just to be able to run through all of those statutes. I mean, just so you know, that usually is a full year, if not a year and a half worth of teaching. So I'm very much appreciative that you set that out, because it's important for us to understand that there are things that are there and that are very often not used. I will just tell you that some of the statutes that we just looked at are ones that are not often used and not often followed, even with regard to the federal government and some of the statutes that are there to handle matters of civil rights violations. So Let me start out just by saying that, that's always my disclaimer, that it's all for educational purposes. Welcome to use it, please. But I think it's really important to look at the backdrop. First, I'm going to talk a little bit about some historical components before we actually get into some fact-intensive situations and that deal with real case scenarios. Slavery, obviously referred to as the original sin of America. I think there were many other sins, but the issue with regard to slavery really takes us to an understanding of what led to the determinations that we saw with regard to the concepts in Dred Scott, and that individuals came to these countries as enslaved persons, placed in the bottoms of boats, and transported across an ocean so that they would then be free labor, and that those individuals then had that part of their history, their presence in this country, as it was considered to be a sin. It was also a travesty against humanity. And many times we don't talk about that. Many times we don't call it for what it is and what it was. But the reality is that it served to be something that was something that we all need to share, particularly in Black History Month. We need to talk about that. And I just got to offer a conversation with a number of legislators in Suffolk County, which I'm going to talk about in a second, later on in this discussion, about what's happening in today. We're in 2022. And still we're seeing some of the very issues that plagued us from the beginning of this country still existing and not being discussed. And that's part of our sickness, if you will. Many people don't realize that the concepts that led up to Dred Scott and others had a foundation in the Constitution and discussions that were part of what was commonly referred to as the 3/5 a person concept, which was, and how many people in the audience ever heard the concept that it was once discussed that African Americans were 3/5 a person, right? Well, many people don't understand where that came from. It came from a compromise and discussion about how tax dollars were going to be apportioned, and essentially how geographic areas were going to be dealt with regard to counting the number of people in each area in the country. And the South had the majority of slaves on plantations. So rather than give them a full count, they counted these individuals as less than a person and called them 3/5 with regard to counting them in the census data. And that's why it's very important when we talk about census every 10 years. A lot of folks don't realize how really important it really does become, because it becomes not only an issue of power, it becomes an issue of say in how government will be run. The 3/5 compromise, which I just spoke about. And then this is something that Mark just spoke about, which I think is something that very few people have a real understanding of. There's a film that I'm going to encourage you to take a look at. It's called 13th. And if you're not seeing it, take the time to find it and look at it. But the 13th Amendment, which basically ended slavery officially through a constitutional amendment, also replaced slavery with what we call the exception clause. The exception clause was essentially replacing the word slavery with criminal. And if you will take a look at some of the numbers we're going to look at in a little while, you will see that following the 13th Amendment, the rise and level of those types of crimes that Mark spoke about, things like vagrancy or criminal mischief or disorderly conduct, or those type crimes which are commonly and often used even to today, and we're going to see examples of those, that those replaced the concept of slavery so that you had essentially a free body of labor that would be part of an institution that could not say no to being forced into labor. And many think that the Emancipation Proclamation ended slavery. It did not. It only dealt with situations with regard to those individuals that were not in rebellion against the United States, but also it did not end slavery. What it did was, through that emancipation, create a situation where there was much conflict within the country about not only Lincoln's War Act, but with regard to the status of African Americans within the United States. So the 13th Amendment, as I mentioned before, went hand in hand with a number of things. One, black codes. The black codes that existed in the United States, largely in the southern states, which made different acts of African Americans, including such things as being taught to read, or standing on a corner, more than 3 persons. I often joke with some of my buddies where we have to look around because I'm saying, there's 3 of us standing here, you know we could be arrested. But that wasn't a joke. That was real. And as a result of that, and many of these laws stayed on the books well into the 50s and 60s in many places, and sometimes into the 70s. And many of you may have read the book, it's now several years old, but by Michelle Alexander, The New Jim Crow. In that book, she does talk about the laws that sent more black people to prison than ever before. And by the late 19th century, there was this thing that she refers to as the prison boom. And we now see the prison industrial complex being a place where we see a pipeline going from high schools or schools right into prison. And much of what has been discussed in a number of books tell us that that institution, that setup, if you will, is something that is not by mistake, and it is not something by happenstance. It is something that is actually planned on with regard to utilizing those things which preceded where we are today. So let's start talking about some real life situations. I hope this comes out, and I want to take a look and see how clear that is. You may not be able to make it out, but let me just point here that this picture is of a Long Beach police officer. And the reason why I'm starting with police is because part of what we see, particularly in the anti-Klan acts and the Klan Act statutes, was that many of the people that were involved were not just citizens, they were members of government. They were supported by police. Things were allowed to be involved with local sheriffs and legislators. And this is a test for you to be able to evaluate what Mark spoke about, because the Section 1983, Section 1981, Section 1985, even though we're often faced with the corporate conspiracy defense in that if they're all part of the same police department, they're saying they couldn't have conspired with each other. Judges are still buying that, and I'm still selling it. But in this situation, it's really important for you to realize that this officer that is here is dealing with my client. I've gotten his permission to use his name, Mr. Benny. Mr. Benny was out with his friends at a bar in Long Beach, Long Island. Go down toward the water. And he had been in a bar, and in the bar, there had been a fight. The fight included white individuals. He and his friends were African Americans. When the fight started, they kept to themselves, did not get involved, and then the bar closed. And they said, okay. They did what? They had been drinking. Did they get in their car? No, they're smart young men. They called an Uber. And they went outside to wait for their Uber car. But as they went outside, 3 of them standing on a corner, the police came to them and said, what are you doing here? And began to harass them. And then began to put their hands on them, even though, and one of the officers, one of the young men said, why are you talking to us? We had nothing to do with this fight. Matter of fact, the guys that were fighting are right there. Those individuals, consistent with our discussion a little earlier, were allowed to just walk away. But the young African-American men that were coming out of that bar, each of whom had 2 beers, said, we're waiting for our Uber, we're not messing with you, officer, leave us alone. And then what they began to do is push them and put their hands on them. And one of them said, you can't do that. My client, Mr. Benny, took out his camera and started recording. And as he recorded, the officers did not like that. And what they did was they started telling him, get across the street, get further away, you're interfering with our investigation. And the investigation was that they had thrown his buddy to the ground, placed him in handcuffs, and roughed him up to the point where everybody's saying, why are you doing that? He didn't do anything. So Mr. Benny did not relent. He began to record and continued to record. And then he started saying, I want your name and your badge number. I know my rights. And he said that over and over again. He did obey. He went to the other corner. And then he stayed on the sidewalk. And he came off the sidewalk once, then went back on the sidewalk. And that's important because he was being obedient, yet trying to exert his rights. As he continued to record, he said, I want your name and your badge number. The officer said, that's it? Clear the area. And he said, no, I'm not clearing the area. I'm within my rights. The officer said, that's it? You're under arrest. And this officer then went behind Mr. Benny as he was standing on the sidewalk and body slammed him. Anybody seen WWF with where they do the Suflac thing and you lift somebody up and you throw him over your shoulder so that he lands basically on his head? Well, that's what he did to Mr. Benny. And Mr. Benny at first didn't know who this person was because the person had gotten behind him so quickly. He then threw Mr. Benny, and you can see here that he has him in a bear hug from behind, and we freeze framed it so you can see Mr. Benny being flung down face first into the concrete. Oh, excuse me, the concrete sidewalk that he was on. Now, many of you may look at this picture and said, why is there a picture of George Floyd in here? This is not George Floyd. This is Mr. Benny. Look familiar? And with regard to this knee on Mr. Benny's head and his neck, his friend said, do that. Arrest him. Do whatever you got to do, but take your knee off his face, off his head. And the officer told him to get back or he was going to effing arrest them. And they did not relent. They continued. And finally, the knee on the neck and the head came off. Mr. Benny was then arrested. Anybody want to tell me what he was charged with? Obstructing governmental administration, resisting arrest, and there's one, no. Disorderly conduct. The disorderly conduct was he was causing a almost riotous situation by demanding the officer's name and badge number. You can't make this up. This is what Mr. Benny's face looked like when he got to the hospital after being released. And by the way, no assault on a police officer, right? There's no allegation of that at all. Picture speaks for itself. His teeth were knocked out. Him in the hospital gown in the hospital, because these are the scars that you can see. These are the pictures that show that his face hit the concrete. But these are the injuries that you can't see. Torn rotator cuffs, injuries to the shoulder requiring 2 surgeries, internal fixation or problems with regard to his shoulder and his arm, forever ruined because he asked for a badge number and a name. The charges against Mr. Benny were dismissed outright, fully dismissed. But now he has the one that has to sue using 42 United States Code section 1983 and 1981, which becomes difficult to prove because we have to prove that this officer sat upon Mr. Benny because of his race. But we bring that anyhow because it's important for us to raise that issue before judges and educate them that there was no reason for this officer to treat Mr. Benny as he was, because he was not a perpetrator, he was not in the fight, and they let the white people go. And sometimes judges cringe when you say that. And I say, cringe on, Judge, cringe on. Because if you are not confronted with the realities that our history brings to us, you are just going to allow it to continue to happen. And judges get challenged. They must be challenged, as we must challenge the systems and the institutions that allow the perpetuation of systemic issues, such as race discrimination and gender discrimination and discrimination with regard to sexual orientation and disability and all the other isms that exist. Let's take you to the next one. This is my client, Mr. Danzy. Mr. Danzy died 3 times. They resuscitated him 3 times. He was coming from paying a bill right here in Hempstead Village, paying a bill so he can get his license back. He was walking. After paying his ticket, an officer called to him and said, "Yo, man, come here." And my client said, "No, man, I'm not coming there. I have no interest in speaking to you. I don't want to talk to you. I'm going to the bus," and continued to walk. The officer then grabbed Mr. Danzy and put his hands on him, and my client said, "You don't need to touch me." They then pushed him up against the car and asked him his name, and he told them his name. And then the officer, for no reason, except for we did find out the reason, and I'll tell you at the end, began to punch him and kick him and called for backup. And Mr. Danzy, at that particular point, went down to the ground. When backup came, he was beaten with an ASP, A-S-P, which is a retractable baton. He was beaten about his head, his body, his neck, his arms, his legs. He had more bruises on him than a 15-year-old banana. And he looked terrible. There was so much blood on the ground that the Hempstead Volunteer Fire Department had to come and hose down the entire street. They then charged Mr. Danzy. You ready? Somebody help me out. Resisting arrest, disorderly conduct, obstructing governmental administration. No claim of any assault. And Mr. Danzy then ended up having these staples in the front of his head. And I took the deposition of the officer. And the reason I raise this is because Section 1983 was intended to try and dissuade these type of things from happening. That being official actors, state actors engaging in these type of civil rights violations. But this is what has been countenanced and allowed in the transcript. This is an excerpt of one of the officer's transcripts, and I only give you one because they were all the same. Q is the question, me asking. Did you see any injuries to the upper part of Mr. Danzy's head as depicted here at the time that you made contact with him or saw him being handcuffed? Of course, there's an objection to form because my adversary didn't like the question. And I'll remind you what the injury looks like. You can answer the question. No, I didn't. This is an officer that had him in his custody, had him in front of him, saw the blood, and saw no injuries. This is the back of his head. 9 staples again. And our expert was prepared to testify about the instrumentality of this type of injury, because this is a more of a straight line that comes from a baton. Testimony of Officer XYZ. Did you see anybody strike Mr. Danzy on the back of his head? That being where those, it looks like 9 staples are. No, I didn't see anyone. I didn't see anyone, no. Then going down. Did you see him have any injuries to that part of his head at any time while he was in custody? I didn't see any. The injuries that were identified to the back of his head, and the injury right there pointing. Can you explain how these injuries occurred? His answer, I cannot explain that. Not a single one of these officers were brought up on charges. Not a single one of these officers, even though we disclosed this testimony, because they were never questioned, not a single one of these officers lost a day of pay, got no re-instruction, or suffered any type of discipline. This is not unusual. And as a result of that, as we look at these real situations, it's very important for us to understand that the laws on the books are only as good as the application that we put to them. And the reality is that in this situation, the demanding of action doesn't just have to come from the victim. It should come from the people that are in the communities that say, what are you doing about police reform? What are you doing about civil rights? What are you doing, elected official, when I put you there? But far too often, we do engage in a conversation that says, that's awful. Somebody should do something about it. Well, we have the capability of doing that, and that's one of the reasons when we look at the Voting Rights Act of 1965, and even though it's been eroded, we still fight like the Dickens to make sure that people have the right to go to the ballot, to not only take care of their birthright, but also exercise that franchise. Let's talk about Mr. Danzy's injuries. And by the way, Mr. Danzy did have some drugs in his system. That didn't mean that they had a right to beat the crap out of him, excuse me, right? He did have, and he said, I smoked a joint, it made me feel funny, the joint was 2 days ago, and it was still in his system. So in this, they tried to say, well, he was high on drugs. The reality was that those drugs had gone long past into his system and were actually out of the point where it would have had any effect on him emotionally, psychologically, or physically. This is how we know he took a beating. Not only did he have a fracture to his face on the left side, concussion, and he was knocked unconscious and had amnesia, but a blunt bowel injury. That means that he got beat in his lower body and through his rectum. He was beat so bad that he had bruising all over his body, and he was beat with regard to his kidneys to the point that he went into renal failure. He died twice, 3 times, and had to be resuscitated, as I mentioned before. And so when you see oftentimes the medical's coded, that happened to Mr. Danzy. You see others, kidney failure, respiratory failure, closed fractures, fractures to the head and the face, open wounds to the face, internal structures, stitches to the mouth, open wounds all over his body from beatings. And most of every injury to his arms was on this side of the arm, where he's trying to shield himself from being beaten. Him in his hospital bed. Here's one of the injuries that shows that he was beat in the face, and you may not see it, but I want to point to it. Suture of his tongue. They beat this man so bad that he bit his tongue in half. By the time that they had finished with him, all of his teeth had been knocked out. In the front, he has a permanent plate. He has plates inside his head and had to have surgery with regard to that. We did well from him, money-wise. We got him a good amount of money. But nothing will take away the nightmares that this man has. Nothing will ever take away the sound that he heard as he heard his skull cracking. And nothing will ever take away his concern that every time he walks down a street, when someone calls to him, that this comes back to his memory. Civil rights laws are important, but civility and how we deal with each other in society with regard to those components that separate us simply by what God has done is something that we need to get to. His color, his race, his background, his slant of eye or language difference should not make a difference. And I told you that we found out what happened and what led to this. Not only did someone not like him because he was walking down the street, but he was dealt with in this way because apparently he had a conversation with a woman who was, somebody's head went, huh? A woman who was working on the side of the road, you know, the flag people, and he thought that she was cute. And he said, hello, how are you? You look good in that uniform. And she said, hi, how are you? And he said, can I have your number? And she gave him the number. And he gave her her number. He had one conversation with her and forgot all about it. It happened to be the girlfriend of the police officer that grabbed him on the street. And because of that, 3 or 4 other officers beat this man to death. Government studies nationally show that there's a difference between how African Americans are treated with regard to crimes, with regard to alleged crimes, and with regard to arrests. And this is just with regard to Newsday showing that on Long Island, rates of individuals in 2017 who were arrested with regard to marijuana charges were not once, not twice, 5 times more likely to be arrested if you were a black person. Out of 100,000 whites, 5. Out of 100,000 African Americans, 20. We don't stop there. We look at most recently with regard to 2020 Suffolk County arrests. And these are arrests not coming from numbers coming from me. These are the numbers coming from Suffolk County's actual numbers reported. The statistics show that with regard to total arrests, 8,715, and that 84% of the population in Suffolk County is white. Total number of arrests that were white, 4,124. Total African Americans, 2,118. Oh, well, that doesn't sound too bad. I'm so glad I had to take statistics twice in college, right? Because statistically, it is significant. Because African Americans in Suffolk County only make up 9% of the population. Yet they're more than half of the arrests that are taking place with regard to misdemeanors. And Latinos are not doing much better with regard to that either. Nassau County, same analysis, similar statistics. As a matter of fact, we see that 30% of African Americans and 25% African Americans of the arrests for misdemeanors, when they are 20, or I guess that would be 31%, or 32 or 33%, 32% of the population. So let's bring it recent. How about you make a complaint against an officer? These are statistics about what happens when internal affairs, there is no civilian complaint review board on Long Island. Did you know that? There's no place for you to make a complaint other than to the police themselves. In Suffolk, they're now going to say you can make a complaint to the Human Rights Commission, but they then hand it over to IAB, Internal Affairs Bureau. And nobody makes any decisions except for the police. And these are the findings. In 2020, 2019, 93% of police, when people made complaints, were exonerated. How can that be? How can it be over and over again? That means that in all those times when someone said they were unprofessional, or they cursed at me, or they used racial epithets, or they beat me, that the civilians were wrong. And that the police officers, as a result, no training, no retraining. And why do I raise this? Because Section 1983, 42 United States Code Section 1983 was created to try and prevent this from happening. Proud Boys, marching in Patchogue. Everybody says, oh, well, you know, Klan is a thing of the future. Heck no. The reality is that there are real concerns today. And just in Patchogue and Bayshore in October, they marched right down the street. While Black Lives Matters individuals were being told, get on the sidewalk or you'll be arrested, and indeed many were arrested, in Long Island in October, these individuals with this big old truck with music blasting stopped traffic, walked down the street, and not a single citation or a single warning or even the presence of police was about. This is Long Island. Stickers all over the place, and these are just some examples. The Proud Boys. And when we talk about, you know, Proud Boys, whether or not it's the Proud Boys, the Aryan Nation, Posse Comitatus, the World Church of the Creator, or the Ku Klux Klan, much of this is all related to hate. And the hate of individuals based on the color of their skin, their religion, their background, or their speech. I've had clients that got arrested because they allegedly flipped gang signs. Everybody, oh, he's a member of a gang, he flipped a gang sign. Well, this is the white supremacy sign being flipped by this individual. And I'll tell you what, with all the facial recognition stuff that we have these days, it's not hard to figure out who this person is. But not a single advance toward this. So we don't need to go into Suffolk County. Let's go to Rockville Center. November 2021, right down the middle of the street, and went into the shops and harassed the individuals that were shopping on a Saturday, and nobody got a single citation, arrest, or anything. I'm just saying, I was on a number of picket lines. Had I gone off the Black Lives Matter into a store and rousted shoppers while I was marching down the street in Baldwin, y'all would have had to come get me. But why the difference in the treatment? And that's why it goes back to the issues that we talked about with regard to the concerns that we have historically. The differential treatment, the 3/5 concept, the differential treatment that allows even legal officials to blow you off. Many of you know the tragedies of lynchings that have not really stopped. They have taken a different view and picture, but when we think of Mr. Byrd, who we think about, that was a lynching. The man was dragged to death in the back of a pickup truck. And when we look at this picture, I want to point out to you what is ingrained in the American history. Don't look at the people that are the strange fruit on this tree. Look at the people at the base. As though this is an event, as though this is a public outing, people holding hands and smiling. There's a concern here when America does not address these concerns. And as we are in Black History Month and we are talking about civil rights, the importance of understanding that we have not yet had the conversation. We do not have the ability to have the dialogue because nobody has the vocabulary and nobody wants to have it. Until we force the issues, the good people that are in this room and the people that may see this video later on, force the issue, to force people to sit at a table and talk about the issues of what happened with regard to the Middle Passage, to talk about what happened in Jim Crow, to talk about the black codes, to talk about what happened to Mr. Byrd, talk about what happened to Mr. Benny, to talk about all those situations, and that these individuals that are hanging at the end of a noose need to be remembered, because this is a noose that was hung in March of 2021 in Suffolk County at a workplace, when a young African American by the name of Kyron Taylor, who had spoken to a white member of his employment, a coworker, and said, I don't work for you. I work for the other gentleman. I'm not taking orders from you. And the gentleman said, I'm going to get you. Several weeks later, this noose was hung in Kyron's workplace. He came in and he said, what the F is this? I'm going to just warn you, you're going to hear a couple of choice words, but we're all adults here. And I'm going to play some video for you that may very well tell you what it was Kyron not only was subjected to, but what type of excuses people make when faced with the realities that Kyron Taylor came into work and two of his coworkers hung a noose to terrorize him. And by the way, one of the laws that we pointed out, Penal Law 240.31, makes it very clear that this type of thing was a crime. No question about it. I hope that this will play. And I'm going to ask our techie in the back, do I need to do anything to start to make this video play? I'm not giving up yet. Yeah. Yeah, it is. It is. It's embedded. You know what? Don't worry about it. Don't worry about it. Okay, we're not going to worry about the technical issues, but let me just tell you. Kyron has his union rep there, and he has recording. And the union rep comes, and to the credit of the union rep says, I've never seen an effing noose being used for rigging of any type. I've been in the union for all these years. And then the boss says, well, yeah, I know who did it. And the union rep says, do you have video of this? And he says, yeah, we have a camera in there. Well, by the way, now the camera, apparently the video is gone. And he then names the individuals, and he says, but I don't want you to involve the individual by a certain name in this, because he's in the apprentice program. And the union rep says, if this person did this, we don't want him in the apprentice program. And the boss basically walks away. Kyron goes back into the area where the boss is, and he gets chastised for calling the police and calling the union and saying, why did you do that? You should have spoken to me first. And Kyron says, would you have protected me? And he says, oh, well, I would have treated you just like anybody else. And Kyron says, this is not right. Kyron is now suffering from a post-traumatic stress disorder that he's being treated for, because the next day he tried to go back into work, and he was made to work with the very guy that put the noose up. We're going to sue. We're going to sue under all the civil rights laws in 1981 and all the other things. But now you have a 24-year-old man who made a complaint to the police and the district attorney's office. Now, this was April of 2001. To this day, no one has been arrested, no charges have been brought, and Suffolk County basically has thumbed their nose at this young man who experienced this. The civil rights laws are only as good as they are applied. This is Kyron Taylor. And I think it's always important to put a face to it. Last point I'm going to bring to you, just so you understand. Suffolk County Historical Society Museum. What is the Historic Society supposed to be the keeper of? Somebody, it begins with an H. Somebody help me? History. This is Black History Month, right? 2 days ago. I'm so glad I could put this in here. Photo of the week in Black History Month. Our history, our heritage, our people. Riverhead Klan, number 31, a picture of an old Lizzie Ford, Model T Ford, with Ku Klux Klan members going to a rally. In Black History Month, and I did not have enough room on this to put the narrative that they put down there, but it was insensitive, didn't mention Black history, talked about the Klan as being a place where teachers and politicians and sheriffs were members of, and then they had the nerve in it, historically, the Historical Society, to say that they no longer existed after 1930. They got barraged yesterday and today from every civil rights group, anybody that had a civil rights bone in their body. We said, contact these people. And now they're saying, oh, we're sorry, we didn't mean it. You did mean it because you're the Historical Society. You're supposed to be the educated people. But when you tell history through one lens and you feel so comfortable that you can't include other people, you in Black History Month are able to do something like this that makes your skin crawl. And if you're a person who's caring, black or white or Hispanic or Asian or Native American or any other flavor of person, and you care about this, when something like this happens, you can't be silent. Because people were silent when Peter was whipped. And you may see this is out of the Library of Congress. This was a slave who, a enslaved person, because he didn't come here as a slave, who was beaten so much that the keloids on his back became something that was just normal. But this is not normal. The beating of Mr. Benny is not normal. The hanging of a noose for Mr. Taylor or the beating of Mr. Danzy is not normal. And when we start to normalize it, we then dehumanize individuals, and they do become 3/5 a person. This next slide comes from a picture that just tells you what the foundation is that we're built on. It comes from the Wilberforce House Museum, and there are a number of these all over the country, but this tells the story. This is the hull of a slave ship. And I had someone count this, it's over 340 people in this ship. The bottom picture is the bottom of the ship, and then the next level is that rung above. And if you'll see, there are numbers here. 174 people, 33 people, 33 people, 11 people, 24 people in the middle, 64 other individuals, and they were crammed into the hulls of boats. If you have a society and a group of people that felt that it was okay to do this, and by the way, we're not talking about something that's ancient history. We're talking about things that continued on all the way into the 1800s. This is why Black Lives Matter. This is why people protested and continue to protest in making the historical statement. Not the argument, the historical statement that Black Lives Matter, because for so long, Black lives were devalued and treated as though they did not matter. But even in our society today, a lot of people need to be educated because they just don't get it. I thank you for the time. And before, and I'm going to ask, come on up. Phil? I always like to bring gifts. So this is a gift to you. Many of you may have seen that I had a mask on that said the Justice Posse. Open it up. You're an official member of the Justice Posse now because the last time I stood him up. And you also have a wristband, which is the Justice Posse wristband. On one side it says Justice Posse, no pain, no gain. And then on the other side, it says.
I gotta wear that.
You're gonna wear it?
Oh, yeah.
Okay.
Thank you.
You're welcome.
Thank you very much.
Thank you so much.
Well, so much for the 20 minutes. I didn't have a heart to stop that. It was too good, too powerful. We do have some time though for questions. So if you could raise the screen, and I would ask. Yeah, that's probably better. Then go ahead and ask questions. Approach the mic if you'd like, or raise your hand, but be loud enough so everyone can hear you, please. Thank you. Oh, yeah, we are recording.
Yeah, so we should use the mic
So
too.
we should use a mic, okay. You gotta turn it on, hold on. He's gotta cue you up.
First of all,
Go ahead.
Yeah, thanks.
first of all, I'd like to thank you for just, I mean, it was so, I can't explain what that talk, I mean, it just was unbelievable. My question is, and this must make your blood boil with what's going on in the schools with critical race theory, where they want to hide all this information and taking the books that people don't agree with out of the system. It reminds me of like Nazi Germany when they took all the books and burnt them. So
So you want us to comment on that? Do you
I
have a
just
question?
want you to comment. I'm sure you're you know.
So my daughter, when she was in 7th grade, so she's 26 now, so however many years that was, her school assigned a book about the Little Rock Nine, the students who integrated Central High School in Little Rock, I think in the late, like 57, 58, 56. And there was a parent, and this was a very quote-unquote progressive school, and everybody was a lot of, let's just say supposedly progressive school. And there was a parent who said in this meeting, arguing that the book should not have been assigned, that she doesn't want her son to feel bad and feel guilty about the stuff that happened in the past. And I became a big hero of the head of the middle school, because I came to the meeting and took the role of responding to that. And I said, you can't read the history of any society without some people understanding that bad things happen and that many of us are participants in it. And I've read history that made me feel bad about all kinds of things, the way the Native Americans were treated, the way the women were treated, the way all of us have participations in communities of people who have something to acknowledge and maybe feel bad about. And education should not be about making sure people don't feel bad or feel guilty or whatever. Education should be about the truth. And my feeling about the whole critical race theory thing is, if you don't like the types of arguments that people are making that are in what people are now calling critical race theory, argue against it. Read it. Read the things you don't agree with. Don't ignore them. Read the things. And if you disagree with them, talk about how you disagree with them. And that's what education should be, that back and forth, that discussion. So it's a bigger answer, but that's how I feel about those things.
How I feel about it is that there is a connection between those individuals who are claiming that critical race theory is something that should not be taught to their children and the backlash that we're seeing in other areas. It's a response. It's a response to what happened to George Floyd. It's a response to a number of things historically that are going on. And unfortunately, when we start to trace where these things are coming from, we also see, and I'm going to say this because we've looked at it very carefully, there are dollars that are being poured into school board elections and other elections, and a lot of those monies are things that are coming from people that we would say are supposed to be upholders of the law. And that's a big concern. The pushback with regard to critical race theory or correct race theory is a concern. The pushback with regard to individuals' rights that forced people to go through COVID in a situation that created a lot of concern. A lot of that language is a lot of the same being pumped out by some of the same people. And when we start to look at that, and I am hoping that someone will do a national release of studies, we're going to see that money coming from organizations, including PBAs, unfortunately, are funding these.
Police unions, that's what it is.
Police benevolent associations, and other similar type of organizations which have systematically been involved in conversations like that where they shouldn't be.
Okay. You've shown us some situations which are absolutely horrendous indeed. So the question arises, could this get worse? It could get a lot worse. And the reason it could get a lot worse is because what happens to a large extent is a function of the people who lead us, as I'm sure you would agree. So we have a situation, as everybody knows, where somewhere between 35 and 40% of the electorate will not accept an election that they don't win. You'll probably agree with this also. That makes democracy very problematic. The only way that I see that we can overcome that is if there is just a massive voter turnout that supersedes the people who believe this way. That's becoming increasingly difficult because of voter suppression laws. You know, so you're of course familiar with the voter suppression laws in Georgia, in Florida, in Texas, which are the worst and probably the most publicized. But they're in countless other states as well. So my question is that as important as it is that democracy is a function of one man, one vote.
One person, one vote.
Sorry, my education
okay.
starts back a little further.
We're with you.
I absolutely.
We're with you.
I should have said that, and you can beat me later on
I'm not
because I
beating-
deserve it.
No, I'm not beating you. But see, you know what?
Okay.
Let me stop you for a second because I'm going to take your question. At the water cooler, in the employment place, if a coworker says that to another coworker, it helps them, right? It's not. You're my brother.
Yeah.
I want you to do it and get it right. And when we start to think that we can't do that, we then become isolated into silos. That type of thing, if I'm telling you, I'm with some of my boys and they start to crack some jokes, I'm saying, I know you didn't do that in front of a civil rights lawyer. And I know you didn't do that in front of me. And as a matter of fact, let's talk about it. For the next 20 minutes, they get educated. But when we don't do that, that's when we perpetuate that lie. And that, in your situation, that's when we don't correct each other and we help each other. Because that's what we're supposed to do. You're my neighbor, you're my brother. I'm supposed to help you. And you're supposed to help me.
Yeah,
But-
and
of
that's
course.
the thing. All of
Okay.
us, any of us and all of us are subject to that. It's never
Yeah.
about
Right.
me,
Uh,
never about chastising anyone. It's about opening
It's historically, I may be right in the sense that it doesn't Baker versus Carr refer to one man, one vote in 1962.
It might, but we're in 2022 now. So,
You're right. I'm just referring to it as an historical issue.
Yeah.
Okay, so going back to where I left off in this thread, why is it that every voter suppression law is not being challenged right now in the courts? Okay, that's one. Two, assuming that that takes place at some point in time and works its way up through the federal court system, do we reach a point where these issues get to the Supreme Court? Because it's a 15th Amendment issue, which I guess is, the federal court system, where you could see a situation where the Supreme Court would not uphold this situation, this law.
So this is what my daughter wrote her thesis about, the Shelby County case, What happened in terms of the undermining of the Voting Rights Act in that case was very specific. The Voting Rights Act had a provision that required what was called pre-clearance, which was for any state that had a history, a tradition of race-based voter suppression. They could not make any changes in their voting registration rules or any other rules that affected voting without having them pre-cleared by the United States Department of Justice and essentially the Civil Rights Division. And by taking that provision out, that's why we've had this explosion of changes in voting rights in different states, and not just former Confederate states, but Ohio, other places, a lot of places in which we've seen these changes. And the court in Shelby basically said, look, we just elected a black president. How could we say we still have a problem in terms of racial suppression of voting? So it was a little bit more complicated than that, but not much. So part of the problem is people do have to sue now, whereas before they didn't. Before, you didn't have to generate a lawsuit challenging one of these things because the U.S. Department of Justice was the entity that challenged them and generally rejected them if they had a potentially disproportionate impact based on race. But actually, there are lawsuits. I think every single one of these voter laws is being challenged in the courts, either state court or federal court. But there was a recent decision, just an example of how that's complicated. So in, I believe, Alabama, there was a federal judge who, to their credit, held that a new redistricting plan had suppressed the voting power of black people within the state, had concluded that it violated the law. And the Supreme Court just issued a stay on that decision in waiting for the ultimate decision, the ultimate vote, which means that that new potentially discriminatory voting structure, the new redistricting, is going to be in place for the next election. So litigation, and Fred knows this way better than I do, is a very long process. And that was one of the reasons why the end of the preclearance was such a big deal. Because if you rely on people to go to court and challenge these things don't take months. They take years and years. And therefore, the changes that are made, they go into place. Then you elect a state legislature based on these changes. And then they perpetuate for years and years the same structure. So there's a reason why people were so upset and so concerned with the changes in the Voting Rights Act, because it has a real practical impact on people's lives.
The gutting of the Voting Rights Act, Section 4, which actually impacted Section 5, was just devastating because there were so many areas in the country that required preclearance by the Justice Department that now it was not an automatic. There are challenges all over the country. NAACP Legal Defense Fund, I'm on the phone with their lawyers regularly. I just recently tried a case against Islip Town to change the form of government there where there was vote dilution going on. And Gooseby versus the town of Hempstead, I tried. Changing the structure of government so that there was not vote dilution going on. I was one of the lawyers that brought NAACP versus the Board of Commissioners, election commissioners, where African Americans were being purged in Nassau County at a rate of 5 to 1 off the rolls. There have been others, Jackson versus the County of Nassau Board of Supervisors, which Judge Spat found that it violated the one person, one vote mandate. There have been many locally. There have been several, and of course the grandmother of them all is Gooseby. Please look it up, Gooseby 1, 2, 3, and then went up to the Supreme Court. Gooseby versus the town of Hempstead, and that changed the form of government right here where we sit. But those do take a long time. When I started Gooseby, I had no gray hair. It took 12 years to try get Gooseby to conclusion. And when you say that, when you ask the question, are they they are being challenged. They're being challenged all over the place. But the problem is, when we saw the issues of federalism and states' rights, and the issues there, they're popping up all over the place like popcorn. And as a result of that, there aren't that many trained civil rights lawyers who can run in and do a lawsuit, right? I mean, this may be, I'm probably not my last cycle, but they come in 10-year cycles a lot of times because of the census. Every time we do redistricting, every time we see things going on and we see gerrymandering, there's a wave of litigation. And those things that are happening now are in preparation for elections after we have this census, knowing that the census numbers are going to impact what's going on electorally. Yeah, hopefully that's helpful to you.
So, my question is I actually have two questions, and the first one is pretty similar to that. But just to be clear, so like gerrymandering and the location of test sites and like at voting sites when they, I mean, I'm only 17, so I haven't voted yet, but when they like check your ID and documentation, that doesn't violate the voting act rights, the
So-
Voting Rights Act.
So voter ID, there's nothing in the Voting Rights Act that expressly says that voter ID requiring picture ID or some sort of ID for voting violates either federal law or the Constitution. The argument would be that if these rules have a disparate impact on different kinds of people, people based on their race, people based on their economic situations, or based on their age. So if it can be shown, and the Voting Rights Act would allow for this sort of claim, or at least, and again, this is one of the reductions. So if it can be shown that otherwise facially neutral rules for voting have a disparate impact on people based on race, that is a basis under the Voting Rights Act for rejecting those rules, and as a basis for preclearance. But another case, less famous in Shelby County, that dealt with voting rules in Arizona, the court recently held that another restriction on the power of the Voting Rights Act, that as long as it's not obvious, as long as it's not necessary that the consequence of these rules will have this racial impact, that it's appropriate to allow them to stand and not to have the court. So no, it's not technically illegal to have a voter ID, but it's arguably a violation of the Voting Rights Act if that rule has a disparate impact on people based on their race or other protected factors.
And a key word there is, does it have a impact which suppresses a particular aspect of the vote for those persons that are intended to be protected under the Voting Rights Act? So there you're looking at a Section 2 challenge.
I grabbed the mic because I know you, Mr. Niles, have to leave to get a.
Actually, we're gonna leave together.
We're good.
Give
Oh.
me a ride, but as long as we're done by about 10 of 8, I think we're good.
We good? Okay. You have another question?
So my other question was, oh yeah. So my other question was for Mr. Danzy and Mr. Benny. How do you like prove legally that it was racially like motivated? And the reason why I'm asking this is because I know this is like, it doesn't relate to it, but in a way it kind of does, because I know for the Hewlett High School District, we just tried to get Eid off as a holiday, and they said no because of several reasons, and we actually had like a lawyer come and speak, but it was like most of their claims were very bigoted and ignorant, and like how do you prove someone's being like racist?
Well, to prove a case in court, it's a lot of discovery and evaluating what has taken place beforehand, and trying to prove what is in that person's mind becomes a question of intent. And in Mr. Danzy's case and Mr. Benny's case, I don't rest my laurels on that claim because it's going to be difficult to prove. But I do rest it with regard to the 14th Amendment and the Fourth Amendment with regard to excessive force and due process and other things that deal with that. But proving the race claim is difficult in court unless you have what's commonly referred to as the smoking gun, where someone says, I can't stand you ins, I'm gonna kick all your butts. And then I go, and I'm gonna do it tomorrow when I see you. Or, but in this situation, for Mr. Taylor, there is a concept that was done because of race, because the noose serves as a well-known symbol of racism and hatred against black people. But with regard to Mr. Danzy and Mr. Benny, that's going to be a difficult case to prove. I plead it and put it in my complaint because it needs to be raised, because I know it, I taste it, I smell it, I just can't prove it. But that's okay, I'm still going to say it.
So just as an example, so the Ahmaud Arbery case, you know about this case in Georgia where a black man was killed by 3 white men who saw him jogging in a neighborhood where they thought he didn't belong. They confronted him, there was a scuffle, and he was killed. And they were recently convicted under the state law for murder, but now they're being charged under federal hate crimes for a crime motivated by racial hatred. So what I saw on my phone this afternoon is there was testimony all day from the FBI showing just really hundreds of statements by all three of these people that were racially biased, using racial epithets, talking about not wanting to be around people of color. And so that's what they're trying to do, the prosecutors, is to say, look, this is who these people are, this is what they did. We can therefore conclude, or the jury can conclude, that it was racial motivation that led for them to do it. Their lawyers are arguing essentially, sure, these guys are racist, but that wasn't why they killed this guy this day. They killed the guy this day because he was a guy in the wrong place and they thought he had committed a crime or something like that. So the question in any legal case, and as Fred said, all you can do as a lawyer is put out the evidence, make your case. You don't know how the people are going to respond, but that's how you prove it. You prove it by coming as close as you can to having evidence that someone can show in court that demonstrates that this was the motivation for the things that he did. It's not always easy to do. In fact, it's almost always very hard to do. But that's what you're trying to do as a lawyer who handles these sort of cases.
I'll give you one good example. One good example was a housing case that we tried recently against Garden City. And in Garden City, we found that Garden City was using its zoning laws to prevent the building of affordable housing to keep persons of color out of Garden City. And a firm that you used to work at, we worked together to prove historically what had taken place in Garden City, and also we went to the minutes of all their board meetings where they used code words, like we want to maintain the character of our community, or those, and that type of language led the Honorable Arthur D. Spat, who's no longer with us, to rule that not only was there disparate treatment, there was intentional discrimination taking place through the actions of this governmental body, Garden City, the one right over there, yeah. And I like calling people out, because if you don't, they get the chance to hide in the shadows. Put some light on it, and that is a great sanitizer.
First of all, thank you both so much. I have a quick question, and it's a little outside the scope, but maybe more so on the scope now that we've discussed kind of Garden City. But I have an interest in like sort of the environmental sector and in environmental justice, and I'm kind of curious how you see civil rights litigation playing into the environmental justice sector, and specifically through that lens. And so it's a little bit of a less of a directed question, and just if you could talk about how you see sort of the confluence between these two important areas of law.
I mean, I'm in conversation with several environmental groups right now about what's taking place with the Hempstead water basin, and what's happening at Hempstead Lake Park, and you see all that defoliation going on. The communities of Hempstead and Lakeview were never consulted. Those are the communities that abut the park. And why did that happen? How did it happen? And what type of studies were done that impacted when those communities down in Sunken City and Lakeview were impacted by the dust? We dealt with that issue in the Voting Rights Act case against Islip, the Roberto Clemente Park, where 40,000 tons of waste were dumped in a town park, and nobody was watching that. And we were able to talk about the environmental impact that had on that community when no one in the town government said anything about it, and the other clusters of waste disposals and other disposals that were taking place in Brentwood but not taking place in Clearwaters. So those issues do come in. I see them as being very important. The problem is, once again, we don't have the troops to handle all of that stuff. There are simply, if you're in law school, if anybody's in law school, come on, we need, is that my friend? Zeus? That's my skateboard friend.
Zeus is in my
Okay,
class. He
yeah,
just had the
we
benefit of
we need civil rights lawyers who want to go out and take on these battles, because there's just simply not enough of us. I mean, I get tired sometimes. Not really, but.
I hope you're training your associates well.
I am. I'm trying.
So quickly, because I actually do have to go after this. When we talk about systematic racism, Zeus, I think one of the most obvious examples of it relates to environmental harm. So you talk about having certain sorts of industrial things and waste sites put in black neighborhoods for intentional reasons. You have redlining, which keeps black people from moving out of neighborhoods that have other kinds of problems. All kinds of way in which, when we talk about a history of institutionalized racial oppression, if there is a perfect example of that, it is issues around environmental justice. So it's not tangential, it's not whatever. I think it's as central as anything else. It's sort of school segregation, the kind of vigilantism we're talking about, and economic injustice. They walk hand in hand in terms of the examples of what folks like Fred work on every day, folks like me teach about every day or almost every day, because I'm a law professor, so a couple days a week. But yeah, it's central. It's not tangential, it's absolutely central. So it's a great question.
I want to thank you both very much. I offered her your email addresses
Can you get,
so that you could make the train.
okay,
You're good?
yeah.
Okay. Oh, good.
I'll try to keep this brief. So on the topic of the abuse of power by police, does defunding the police seem like a legitimate solution?
No.
Can you elaborate?
Yeah. I believe, and I'm part of a group, look it up online, LifePol, Long Island Advocates for Police Accountability. We wrote the People's Plan that dealt with police reform. We don't advocate, and I don't advocate, defunding the police. For once, it's one of those buzzwords that just sets everybody off purposely, and nobody says anything to anybody else after that. The second thing is that defunding the police is not a practical component about it, because there is crime. There's crime, we just deal with it totally inappropriately. And the funding of police is an issue, but it's not an issue of defunding, it's a matter of redistributing the funds so that we can then handle some of the social ills that we're facing that underlie the reason why police say they have to use force, which is not true, right? So that's the short version, knowing that we gotta get to the train station.
And I think, yeah, so reinvest as opposed to defund, refund, other sort of things, I think, for a combination of reasons. That's the way. If it were me, I would articulate it. And a lot of my friends don't articulate it that way, and I'm trying to encourage them to find a way to articulate it that's going to be more accessible to lots of people.
Do we wanna talk?
Yeah,
Don't shut people down.
right. Thanks, folks.
Thank you both very much. This will have a